Hello, my name is Jessica Goldrick from McMahon Goldrick Solicitors, and I'm going to talk to you today about the law of medical negligence in Ireland. A medical negligence claim may arise if you have suffered an injury as a result of medical mistreatment or a lack of proper medical care. Medical negligence can be a factor in cases involving spinal injury, brain injury and birth injuries, as well as other life-changing injuries. These cases can result from delayed treatment, failure in diagnosis or treatment, such as negligently performed surgery, not providing patients with accurate information, or not involving them properly in the decision-making around their own care. So what is the test for medical negligence cases in Ireland? You must be able to prove the following. Firstly, a breach of duty. Was there a breach of the duty of care owed by the medical practitioner? And did that breach of duty cause the injury in question? Secondly, can the medical practitioner in question be proved guilty of such failure that no medical practitioner of equal specialist or general status and skill would be guilty of if acting with ordinary care? The test for medical negligence was set down in 1989 in the seminal case of Dunn versus National Maternity Hospital in Jackson. In this case, the infant plaintiff sustained irreversible brain damage and catastrophic injuries at birth, and his mother on his behalf brought a claim in the High Court seeking compensation for those injuries. The facts of the case related to the alleged negligent mismanagement of the last 6 hours of the mother's twin pregnancy and labour by failing to monitor 2 fetal heartbeats instead of 1. This was the very first birth injuries case to come before the courts, and the decision of the High Court was appealed to the Supreme Court. The Supreme Court's judgment summarised the legal principles which the court should apply in all cases of medical negligence, and since then they have become known as the Dunn Principles. The Dunn Principles are as follows. The test for establishing negligence in diagnosis or treatment on the part of a medical practitioner is whether he or she proved guilty of such failure as no medical practitioner of equal specialist or general status and skill would be guilty of if acting with ordinary care. The fact that the negligence allegation is based on the fact that the medical practitioner deviated from a general and approved practice will not in and of itself establish negligence, unless it is also proved that the course he took was one which no medical practitioner of like specialisation and skill would have followed if he or she had been taking the ordinary care required of a person with his or her qualifications. If a medical practitioner charged with negligence defends their conduct by establishing that he or she followed an approved practice, this is one which was approved of by his colleagues or similar specialisation and skill, he or she cannot escape liability if in reply the plaintiff establishes that such practice has inherent defects which ought to have been obvious to any person giving the matter due consideration. An honest difference of opinion between doctors as to which are the better of the two ways of treating a patient does not provide grounds for a judge to make a finding of negligence. And lastly, it is not for a judge to decide which of 2 alternative courses of treatment is preferable. The judge's function is to decide whether the course of treatment followed by the defendant doctor, on the evidence, complied with the careful conduct of a medical practitioner of like specialisation and skill. Birth injury claims involving children who were injured during the course of labour, delivery or the neonatal period are some of the most distressing and tragic cases that come before the courts. Typical injuries that lead to a birth injury compensation claim are often related to the baby not receiving sufficient oxygen during or just before delivery. This can be caused by inadequate monitoring, failure to diagnose a condition, with the mother experiencing complications during the birth, or improper handling of the baby once it's born. A reduction in the supply of oxygen to the brain may cause brain damage or lead to some other form of permanent disability, such as cerebral palsy. Birth injuries which can arise as a result of medical negligence include the following: cerebral palsy, hypoxic ischemic encephalopathy, PVL or periventricular leukomalacia, Erb's palsy, and brachial plexus injuries. Maternal birth injuries can also arise as a result of medical negligence, and they can include the following: vaginal and perineal tears, neurological complications as a result of epidural or spinal anesthesia, nervous shock, which is a recognisable psychiatric injury induced by the defendant's actions. Spinal cord injuries can also be caused by medical negligence, and they can arise or be exacerbated as a result of things such as delayed medical treatment, for example, a failure to refer a patient for treatment or in carrying out the necessary procedure, misinterpretation of radiology and scans, carrying out the incorrect operation or procedure, for example. Brain injuries can arise or be exacerbated as a result of medical negligence. Examples of cases that have been made on behalf of plaintiffs are cases where there was delayed medical treatment, for example, mistakes or delays in recognising and treating conditions such as a stroke or meningitis, misinterpretation of radiology and scans, inappropriate surgery and surgical technique, failure to recognise symptoms early in the course of pregnancy and labour, and an error in administering the wrong medication, for example, a prescription error. If you believe that you may have a medical negligence claim, it is important that you choose specialist solicitors to handle your case. We at McMahon Goldrick Solicitors specialise in medical negligence and serious injuries. At McMahon Goldrick, we pride ourselves on the standard of care that we offer to our clients. We act exclusively for individuals and families that have been affected by spinal cord injury, traumatic brain injury and birth injury, resulting in a permanent disability. Please, as always, feel free to contact us with any queries that you might have on a confidential and non-committal basis. Thank you for your time today.